Hi, and welcome back to this Thursday edition of Focal Point on AFR Talk. Brian Fisher is my name. This is Focal Point, the home of muscular Christianity on conservative talk radio. Now, the thing in Arizona, that's done. Governor Brewer caved. She folded. She didn't have the courage of her convictions. She weakened under this relentless pressure from Big Gay. She collapsed under the weight, couldn't stand up against it, didn't have the courage, didn't have the fortitude, didn't have the character to stand up for the Constitution and religious liberty and for her own constituents in the state of Arizona. Now, also yesterday, we brought you this breaking news at the end of the broadcast yesterday that a federal judge, a judge by the name of Orlando Garcia, overturned the marriage amendment in the state of Texas. Now, the marriage amendment in the state of Texas, it defines marriage as a union of one man and one woman, and it prohibits the recognition of counterfeits. So it's a way of protecting the genuine, authentic currency of God-given marriage, God-designed, God-ordained marriage, and refusing to grant any currency or credit to counterfeits, to marriage relationships that are pseudo-marriages. They're fake marriages. There's nothing genuine, authentic about them. Because marriage clearly, according to God's design, according to the scripture, as the founders would put it, according to the laws of nature, and nature's God is the union of one man and one woman. And by the way, you'll hear a lot of liberals out there citing Thomas Jefferson as if he would be a supporter of same-sex marriage. This is absolutely not true. It's totally bogus. In fact, Thomas Jefferson penned the Declaration of Independence in 1776. Now, he was out of the country when the Constitution was debated and the First Amendment and all that. But in 1778, just 2 years after he wrote the Declaration of Independence, Thomas Jefferson wrote a bill that was enacted into law in the state of Virginia that provided castration as the punishment for sodomy. I'm using the legal term sodomy. That's the word that Thomas Jefferson used. Perfectly good legal term. You can look it up in the dictionary. It's an ugly word because it refers to an ugly practice. But Thomas Jefferson was the guy that wrote that bill that said for sodomy, the penalty ought to be castration. And for lesbianism, the penalty was to have some kind of a hole drilled in a woman's nose. Now, I'm not saying we ought to do those things today. That's not my point. My point is Thomas Jefferson is the wrong guy. If you're looking for a founding father to back when it comes to same-sex marriage, Thomas Jefferson is the wrong horse to back. Now, the marriage amendment in Texas was passed in 2005. Now, like a lot of states, it had to, first of all, pass the Texas state legislature. And it passed the Texas House by a margin of 101 to 29. 101 for, 29 against in the Texas House. In the Texas Senate, it passed 21 to 8. And then when it went to the people for a vote, it got 76% of the vote. The marriage amendment carried 253 out of the 254 counties in the state of Texas. So it passed with overwhelming support, more than 2/3 in both houses of the state legislature, 76% of the people, 253 out of 254 counties. So it's very clearly then without any mistaking, and Governor Perry, governors don't sign constitutional amendments into law. They don't have a signing ceremony because there's nothing for the governor to sign. This is something that's done by the people. So when the people vote and the votes are tallied, then the Constitution is amended at that point. You don't need a signing ceremony. It's a done deal when the people ratify it. But Governor Perry was so supportive of the institution of natural marriage that he held a big signing ceremony. It's symbolic, but a big ceremony brought everybody together. Don Wildman, who was the founder and chairman emeritus of the American Family Association, was down there for that ceremony. So Governor Perry showing his wholehearted, unreserved support for the institution of marriage and for elevating protection for natural marriage to the Texas state constitution. So listen what you've got now. You've got more than 2/3 of both houses of the state legislature, 76% of the people, 253 out of 254 counties, and the governor of the state of Texas, all of them virtually unanimous universal support for this marriage amendment. Now, this judge by the name of Orlando L. Garcia, one judge, overturned that. He disenfranchised the entire Texas state legislature, disenfranchised everybody that voted for those elected representatives that in turn voted for marriage. He disenfranchised all 76% of the voters in the state of Texas who voted for it. He disenfranchised the vote in 253 of 254 counties. This is just blatant judicial tyranny. It is unconstitutional. It is immoral. It is unethical. So this is just a burst of judicial arrogance and judicial hubris on the part of Judge Garcia, disenfranchising everybody with the stroke of his pen. One man. Ladies and gentlemen, that is tyranny. That is not how a Republican democracy works. Now, I talked about this yesterday, but I want to revisit it because it's absolutely critical. It's absolutely important. I believe this could be a watershed moment in the history of America, and I'm not exaggerating. If Governor Perry does what I hope he will do, this will be a watershed moment in the history of the Republic. Because of what we have right now is a mockery of a Republican form of democracy. It's not being honored. It's not being observed. It's not being practiced in any way. A couple of years ago, Denzel Washington starred in a movie. It was a fact-based movie. I read the story about, a pretty dramatic story, about a runaway train. This train got rolling, and the engineer was out of the cab when it started up. There was nobody on the train. And so the train is literally out of control. The name of the movie was Unstoppable. Now, and it's based on a true story, and Denzel found a way to stop the train, and that's how that was the whole story of the movie. But what we've got right now is we have a runaway train, and that runaway train is the federal judiciary. We've got a federal judiciary that is crushing the will of the people and crushing one state after another. 31 states just a few months ago had marriage amendments in force that protected marriage as a union of one man and one woman in their state constitutions. This was done by the people. It reflected the will of the people. They were in force. Now, since then, we've had judges have invalidated or overturned unconstitutionally, immorally. I believe there is no statutory, legal, constitutional authority for what they have done whatsoever. They are blatantly illegal, blatantly unconstitutional. But now we're down to 26. And the trend is very clear. We've got an unstoppable runaway train. Now, I believe Governor Perry can be the Denzel Washington on the same-sex marriage issue. Now, what I hope that Governor Perry will do, by the way, when you'll hear homosexual activists talk all the time about how almost half of America now lives in states where same-sex marriage has been validated. But if you do a study of the states where the people themselves have gone to the ballot box and voted for same-sex marriage, we only have 4.5% of the American people live in a state. Just 3 states have actually voted where the people themselves have voted for gay marriage. They represent 4.5% of the population of the United States of America. Contrast that with the 31 states where citizens have gone to the ballot box and voted to defend and uphold and elevate protection for natural marriage to the state constitution. So we've got sexual deviancy now being imposed on one state after another by these out-of-control federal judges. Now, remember, we've talked about Article 1, Section 8. It lists the only powers of action that we, the people of the United States, have delegated to the central government. If it's not in Article 1, Section 8, you can't do it. Federal government has no authority to do it. They're not allowed to do it because these are the only powers of action that we have given to them. Well, you can read Article 1, Section 8, 19 powers of action there. You won't find a single reference to the central government being given any authority whatsoever to dictate marriage policy to the states. It's not in there. That means Congress can't do it. It has no constitutional authority to tell any state in the union what its marriage policy must be. Federal government simply does not have that authority, whether it's Congress, whether it's the president, whether it is the judiciary. Now, Governor Perry understands this. Here's the statement that he issued yesterday. He said, listen to this, and this is exactly right about this. It is not the role of the federal government to overturn the will of our citizens. The 10th Amendment guarantees Texas voters the freedom to make these decisions. Remember, Article 1, or the 10th Amendment says any power not delegated to the central government is reserved what? To the states or to the people. Well, Article 1, Section 8 does not delegate any authority to the central government to dictate marriage policy, that means what? It is reserved by the founding fathers, by our founding documents, by the Constitution. It is reserved to the states. They have no right. And so Governor Perry is citing the Constitution here. The 10th Amendment guarantees Texas voters the freedom to make these decisions, and this is yet another attempt to achieve via the courts what couldn't be achieved at the ballot box. We will continue to fight for the rights of Texans to self-determine the laws of our state. And they've got an Attorney General, Greg Abbott's running for governor, running to take Governor Perry's place, and he is this morning working on an appeal to the Fifth Circuit Court. But here's my suggestion. Talked about this yesterday, but I want to revisit it again. You ask yourself the question, how can Governor Perry continue this fight? I believe there's a way that Governor Perry can not only continue this fight, but he can win it outright, and that is by adamantly refusing to surrender to this act of judicial tyranny. I believe Governor Perry can uphold both the Constitution of the state of Texas and the Constitution of the United States by declaring that no matter what a federal judge or a federal court decides, marriage in Texas will continue to be a man-woman institution. Governor Perry can issue a directive that no marriage licenses will be issued by any county clerks to same-sex couples in the state of Texas, period. Now, I want to be clear about this. If Governor Perry were to do this, he would not be violating the Constitution. He would be upholding it. It would not be the governor. It would be the judge who is violating the Constitution and his oath of office. So the governor would be doing his part to make this nation once again a nation of laws and not men. And here's where a fresh momentum could be given to the cause of morality and natural marriage. Other like-minded governors might be inspired by his example and inclined to follow suit. Remember, 26 states, the governor is a Republican, and both houses of the legislature are Republican. Now, Big Gay would respond with a flurry, a frenzy of outrage and the flurry of litigation, but what could they do? If Governor Perry simply refused to bow to unconstitutional diktats, what could they do? Now, if the president were to threaten the use of force to compel Texas to submit, that would simply prove to everyone that we are no longer a self-governing people and no longer have even the semblance of a constitutional republic. So, Governor Perry, a nation turns its lonely eyes to you. What will you do? Focal Point, AFR Talk.
It is a person